Hey, what's up everybody? Welcome back to What They Teach You in High School. Today we are continuing our conversation on the United States court system. Specifically, we're taking a look at state courts, federal courts, and the Supreme Court. If you need to remember one thing about the court system, it's that state courts, and really the state government generally, has way more power than we give it credit for. Welcome back to What They Teach You in High School. Remember that whole 10th Amendment where it says that any power not directly given to the federal government in the United States Constitution is reserved to the states? Well, that still plays out even today. And therefore, most of the time when we find ourselves in the court system, we're actually dealing with the state court that you reside in rather than the federal court system. Traffic court, divorce court, child custody, tenant disputes, personal injury, workers' comp, inheritance law. Need I go on? All that to say that state courts manage most of the disputes that happen between people and between the person and their government. And therefore, it's worth understanding how we select the judges who sit on these state courts. So let's take a look at the three main ways that judges are selected in the state court system. The first selection is election. Oftentimes, judges are elected to office, typically in a nonpartisan way, where they're not identified as either a Democrat or Republican, at least on the ticket. Another method is where judges are appointed by a governor or the state legislature. And we also have a blend of the two, where a judge is appointed by a governor or a legislative body, and then voted on by voters after a certain amount of time to determine whether that judge's sort of trial period, if you will, amounts to them being qualified to hold the position for an extended period of time. Each of these methods have their pluses and minuses, but needless to say, there are a variety of different ways that state judges are selected, and it's worth looking into in your state how you select your judges, because the more you know, the more you grow. The more you're aware, the more you care. Let's keep moving. So like we saw in this last video here, you'll remember that there are trial courts, there are appellate courts, and then we have what's called the court of last resort. And in each state, there is a state Supreme Court that oversees appellate court rulings if they so choose to determine whether or not the ruling was accurate. And the Supreme Court of each state gets to determine whether or not they will hear an appeals case in a given year. Next, we have our federal judiciary. The way we have our system broken up is there are 94 different district courts that are smattered all across the United States, including some of the colonies that the United States maintains across the globe. These 94 courts are where the trials begin. These trial courts rely upon a jury to make the decision, and the judge is overseeing to make sure that the jury answers the proper legal questions. In addition to the 94 district courts, there are also 13 appellate courts that oversee these 94 district courts to make sure that the judge applied the law properly in the trial court case. These 13 Court of Appeals have 3-panel judges, almost like a mini jury with an expertise in looking to make sure that laws were applied properly. And just like our state court system, our federal court system has a court of last resort. And you know it as none other than the great, the powerful, the United States Supreme Court. And if you recall from Article 2 of the Constitution, it says that the president, with the advice and consent of the Senate, will appoint judges to the federal court. Let me digress for a moment and just mention that when these judges are appointed by the president and then consented upon by the United States Senate, these judges get to serve for life. That means forever, as long as they're within good behavior, if you know what I mean. It's pretty hard to get fired from the court. What's more likely is that if you're a United States Supreme Court justice nominee, you might get borked. And that's a real thing. Look that up. In fact, here's your visual for that so I don't get in trouble. The United States Supreme Court is the court of last resort of last resort. They can hear any appellate court case that they choose in federal court. They can also hear court cases that have been appealed after the state Supreme Court rules on their decision. However, about 7,000 court cases are requested to be heard by the United States Supreme Court, of which they typically hear only between 100 and 150 court cases. Talk about working part-time. Once a court case has been decided to be heard, the lawyers who represent both sides of the argument create what are called their briefs and then plan their oral arguments, like this.
Mr. Chief Justice, and may it please the court, Section 2 of the Federal Arbitration Act requires that an agreement to arbitrate be enforced unless a generally applicable contract defense renders it unenforceable.
Ultimately, the United States Supreme Court makes one of two decisions. Either they uphold the lower court's ruling or they overturn that ruling. These decisions are decided in what's called the majority opinion and the dissenting opinion. It takes only 5 of the 9 justices to establish a majority opinion, and what they determine is what becomes the new law of the land. Hey, and there you have it, folks. That is the long and short of our United States Supreme Court, our federal court system, and our state court system. Make sure you like, subscribe, hit that little bell button so you know I'm coming next time. Thanks as always for watching What They Teach You in High School. We'll see you next time, folks. Peace.